Okay. So this is really the meat and potatoes of kind of what our work is in terms of the information that we're going to be giving out on the response line. So throughout the training, we talked about CPOs and criminal, but this is really the distinguishing information when we're talking with folks about the civil process versus the criminal process. So we'll go to the next slide. We don't need to worry about that. These are the statistics I reviewed earlier, where it's just how many calls MPD gets related to domestic violence. With MPD referrals, those are all going to be in the criminal system, and then when folks come into the intake centers, often we're walking them through the civil system.
So MPD is always criminal?
Yep, MPD is always going to be criminal. So the next slide, I'm going to distinguish between civil and criminal court. So when folks are coming for a civil court matter, it's a forum between private parties. So it's one person bringing a case against another person. There doesn't have to be any police involvement. And this is just like any other type of civil court, like landlord-tenant court or small claims court, where one person has some kind of a claim against another person. And so they come to the courts to have a judge act as a neutral party to decide on the issue that they're bringing forth. And that judge is also going to be using any relevant laws that affect that particular case. So in civil court, no one is guaranteed an attorney. It's called a pro se process. So unlike criminal court, where defendants get an attorney guaranteed to them, civil court, no one is guaranteed an attorney. And what we actually found is that recently, so we do legal referrals and we work with about 12 different partner agencies. And we used to get about 70% of the clients who requested a pro bono attorney got it. But there have been a whole bunch of cuts that have happened recently. So the last month or two, we've seen about 40% of the clients who request an attorney to help them through the civil process end up getting granted an attorney by some pro bono agency.
Okay, so even though you're not entitled to an attorney, you still can have and would be beneficial to have an attorney.
Exactly. Yeah. Okay. So what we find is that folks who have attorneys, they end up, I think from our last Court Watch data, we saw that they get granted protection orders at like 2 times the rate of someone who does not have an attorney. So you're significantly more likely to get granted a protection order if you have an attorney to your case. There are agencies that will do it for free, but once they kind of hit their caps, then you have to hire your own private attorney.
Gotcha.
And then the terms that we use, and we talked about this at the beginning, the person who's filing for the protection order is the petitioner because they're filling out a petition for protections. And then the person who's being filed against is the respondent because they have to respond to the allegations that are in the protection order. So we'll go to the next slide. So criminal court, that's where the state is prosecuting a person who's been charged with violating the laws of DC. So we'll talk more about this when we talk about what happens when someone calls 911. But it's the government ultimately who gets to decide whether or not they're going to move forward with the case, what they're charging the case with. The victim often, once the initial police report has been made, has almost no control over the process. It's the government's case at that point. So it says, yeah, although there is a victim in the case, they're not party to the case, but they're a witness for the prosecution. So the 2 people that are party to the case are not the victim and the person who committed the crime. It's the government versus the defendant. And a lot of clients get confused because they think that the prosecutor is their attorney. But the prosecutor is acting on behalf of the government's interests, not on the interests of the person who the crime was committed against. Does that make sense?
Yep.
All right. So in DC, there are 2 prosecuting agencies. It's the U.S. Attorney's Office or the Office of the Attorney General. So the U.S. Attorney's Office, they're often the ones that are prosecuting the crimes that MPD takes reports on. The Office of the Attorney General, they do crimes associated with violating a protection order. So if a protection order is violated, it is a criminal activity, and the Office of the Attorney General acts as the government in those cases.
So the Office of the Attorney General, you said, is we really only use those for individuals who have violated protection orders?
Yep. So the other thing about the Office of the Attorney General, they also represent clients in protective order cases, so they kind of play 2 roles. They, one, represent clients as their initial attorney for trying to get a protection order. they also represent the government when a protection order has been violated. So often what will happen is if they represented a client in one case, like if they represented them in the initial CPO hearing, if that protection order is violated, they then cannot represent the government. So they have to hope that the U.S. Attorney's Office is going to then represent or is going to actually prosecute that crime. Hold on one second. Yeah, come in.
Oh, yeah.
Hey.
Hi. You have everybody you need? We can close the doors?
Yep.
Okay, cool.
Thanks, Heather. Does that make sense?
Yeah.
Okay, so they act as like a dual role. The U.S. Attorney's Office is specifically a prosecuting agency for all crimes in the district. The Office of the Attorney General kind of plays both roles. They're either the prosecuting agency or they can represent clients in CPO cases as well.
Okay.
But they can't do both for the same client.
Gotcha.
And then you are entitled.
Even if it's even if it's a separate case from like 5 years ago, could they be in other role, or would it?
That I'm not sure of.
Okay.
I just know that sometimes they're hesitant to pick up cases occasionally when they think that there is going to be a violation of the protection order, because maybe historically there have been, because they want to make sure that they can prosecute that violation later if something happens.
Gotcha.
And then defendants are entitled to attorneys in criminal cases if the penalty faced includes 6 months or more of jail time or it's a felony case.
Gotcha.
All right. So we're going to go into the civil protection order process next. There are flowcharts. I don't know if you have your little handbook available. I'm going to pull up a flowchart in a minute. But if you do have the handbook, there are flowcharts that go through the civil process and the criminal process as well.
Let me just grab that. Okay. Is it in the
It's towards the middle. Yeah, they look like little flowcharts. I think this one is it's long ways, so it's like, what's the word?
Violation of CPO, TPO?
Not violation. It should be right before that, where it's like, how do I get a protection order?
Yes. How do I get a
yes
temporary and or
civil protection order? Yep. So I'm going to talk about it more in narrative format. So I'm not going to go strictly through the flowchart because I think it makes more sense as a narrative. But
okay.
So we'll get there. All right. So the first thing is, what is a temporary or a civil protection order? Temporary protection orders last for 14 days. They're short-term remedies for protection. So the judge can grant it for more than 14 days, but generally for that to happen, the respondent has to agree for that protection order to go longer than 14 days. And we'll get into exactly what these are in a minute. But just know TPOs or temporary orders are generally about 2 weeks, and civil protection orders are generally good for 1 year. So civil protection orders vary across state lines. So one thing about civil and temporary protection orders is that you can get them in any jurisdiction in the U.S., and they are enforceable in any other jurisdiction in the U.S. Meaning, if I get a protection order in D.C., it is still needs to be upheld in Maryland or Virginia or Puerto Rico or anywhere else.
Okay.
But to actually get a protection order, every state or every jurisdiction has different qualifying terms to get a protection order in that jurisdiction. So just because someone can get a protection order here in D.C. doesn't necessarily mean that if they had that same exact case in Maryland that they could get a protection order.
Okay, but if they get it in D.C., it's not like it has to be re-adjudicated in Maryland.
Exactly.
It would still be enforceable in Maryland, but they don't re-review the case.
Yep, so you can register it with the courthouse in whatever new jurisdiction that you move to. So say I got it in D.C. and I moved to Maryland, I can actually take it to the courthouse and register it there. That way the Maryland Police Department has access to it.
Gotcha.
Because otherwise you'd have to carry around a hard copy of it with you to prove it in case anything were ever to happen in another jurisdiction. But that being said, civil protection orders here are really short term compared to a lot of other places. So like if you get a civil protection order in New Jersey, I think it lasts about 10 years. And a lot of that is because we have a really low burden of proof. So we'll talk about it in a second, but the burden of proof for a protection order is something called preponderance of the evidence. Meaning that the judge, when they're making their decision as to whether or not to grant it, they're deciding, is it more likely than not that these incidences happened? So it's like a 51-49. They just have to be more sure that these things could have happened or did happen than they're unsure of. And when you look at other jurisdictions, they have higher burdens of proof, so you have to have more proof to actually get granted the protection order, so they last longer. Both are orders that require the respondent to abstain from particular conduct or acts against the petitioner, or the respondent to do certain things that promote the safety and welfare of the petitioner and the victim. So the protection orders themselves are issued, they're orders that are issued by the judge that all of the things in effect have to be done by the respondent. The respondent is the one who is responsible for upkeeping all of the terms of the protection order, meaning that someone who files for a protection order can never violate their own protection order.
Okay.
All right, so we go to the next slide. So there are 3 things that have to be true for someone to be able to get a protection order in DC. The first is that there has to be an intra-family relationship between the parties, and we're going to go through that on the next slide, what those relationship types are. The next is that the respondent has to have committed a crime against the petitioner. And the third, those 2 last bullets can be clumped together. So the petitioner, there has to be residency. Either the petitioner is a DC resident, which means that they either live, work, or go to school here, or at least one of the incidences of violence has to have happened in DC. Now, for the incident of violence, generally for a temporary protection order to be granted, the judge is typically looking for something that's happened within the past 2 weeks.
Sorry, you cut out the past what?
The past 2 weeks. So if someone wants a temporary protection order, they're looking, has something recently, have you been threatened? Have you been assaulted within the past 2 weeks? For a civil protection order, judges are looking at, has something happened to you within the past 2 years, generally. So I can come in and file for a civil protection order if the last incident happened 6 months ago. But if I want that temporary order, then that immediate same-day order, something needs to have happened generally within the past 2 weeks.
Okay.
All right. So the next slide talks about who qualifies for a protection order in DC. The code, so we don't have domestic violence codified in DC's laws. What we have is something called an inter-family offense. It's called an IFO. And so our statute's a lot more broad than a lot of jurisdictions. So a lot more people are covered under our protection order laws than you find in other jurisdictions. So all of these types of relationships that are on this screen qualify for domestic violence services under the law in DC. So if folks are related by blood, by legal custody, so that could be you're both guardians of an older adult. Related by marriage, so sister-in-laws, brother-in-laws, marriage relationships, being married, having children in common, and then roommates qualify in DC as well. So if you have shared common spaces, like a shared living room or shared bathroom, shared kitchen, you can qualify under DC's domestic violence laws as well. It's also if you have any type of romantic or sexual relationship. So even if you've had one date or one sexual encounter, you can still fall under the definition of domestic violence in DC. This includes same-sex couples. The next one is common intimate partners. You might hear this referred to sometimes as Section 16. That's what it's written in the code as. The idea is that it's a partner in common, meaning, so if I dated Billy and Billy and I broke up and Billy started dating Sally and I assaulted Sally, Sally and I have never had a dating or intimate relationship. We don't have any of these other types of relationships in common, but we have a shared intimate partner. So because of that shared intimate partner, we fall under DC's guidelines for an intrafamily offense.
Okay.
And then the last 2 groups that qualify are folks who've experienced sexual assault or stalking, regardless of any other type of relationship with that person. So for our purposes, generally the judge for stalking is looking at 2 or more incidences of unwanted contact. That's often what they're looking for.
And are there cases that we deal with?
So on the response line, we're going to get calls about most of these types of cases. We don't really get calls that often about Section 16 cases or partner in common cases. But we do get a lot of family violence cases, whether it's like an uncle and a cousin or whatever. And the response line, we generally work with all those relationship types. So we'll place folks in housing and things like that. But in the intake centers, we're primarily working with dating or sexual relationships, marriage, children in common, sexual assault, and stalking.
Okay.
So Section 16 we almost never work with. Roommates, very rarely do we work with them. It's really only if occasionally we'll have like a same-sex couple that doesn't want to present in documentation as being a couple for whatever reason. And so they might fall under the roommate category. But if we, in talking to them, figure out that they're actually an intimate couple, an intimate partner couple that just don't want to file papers saying that, then we'll work with them as well.
Gotcha.
All right, so the next slide talks about a criminal offense. So I mentioned that one of the three things that has to be present to get granted a protection order in DC is that a crime has to have occurred. That doesn't mean, though, that the police have to have been contacted about that crime. So what happens when someone comes in to file is that they're going to fill out this petition for a protection order. And in that petition, they're going to list their names, their relationship, and then they're going to write in narrative format the incidences of violence that have happened to them. And so the judge is going to use that description of the incident to determine if a crime has happened. And if a crime has happened, then they can grant that protection order. Does that make sense?
Uh-huh.
But there's not going to be a police report. The judge isn't going to take that and then file a police report with it. It's just something that they're using to determine if they're going to grant a protection order. So things that the judge is looking for. So types of criminal offenses that could get granted a protection order for someone include assault or attempted battery. So maybe they had tried to hit you, but they didn't hit you, things like that. Hitting, slapping, kicking, punching, spitting, all of those things would count. Destruction of property counts. So breaking cell phones, kicking in doors, things like that. Harm to pets is included in this as well. So maybe the only violence that they've had is that they, kicked your dog or something. That in and of itself is something that the judge can use to grant a protection order. Sexual abuse is included. Arson is included. And then threats to physically harm or kill are also included. So when folks come in to file, they're filling out the narrative and they're starting with the most recent incident of violence. And then they can list as many incidences of violence that have happened to them, dating back as far as they want. Any questions? All right. All right, so the next slide, this is an updated version of the flowchart that's in your book. So I'm going to go through and talk about how does someone come in and file for a protection order. So typically, we're connecting with clients often, a few hours after some kind of an assault has happened, and they're getting referred to our services. So one thing that we're going to talk with them about is what the process looks like for filing a protection order. So the first step is that they have to come to one of the two domestic violence intake centers. There's the one here in the courthouse, and then there's one at United Medical Center at Southeast. These intake centers run on the court's hours, so they can only file for a protection order Monday through Friday from 8:30 to 4. Yeah, the times are not great, and I'll talk in a few minutes about something called an emergency temporary protection order that they can use for extreme cases where someone can't get in when they need to, but it's super rare, like unicorn style rare. So if someone wants to file, the first thing that they're going to do is they're going to come to the domestic violence intake centers. The advocates at SAFE are only going to work with someone if it's intimate partner violence, stalking, or sexual assault. So those other types of relationships that were listed on that page that can file for a protection order, they can still come, but they're going to do something called a self-petition, meaning that we're just going to send them directly to the clerk's office and they're going to fill out the forms themselves. When we have clients that come to meet with our advocates, we do something called enhanced pro se, which basically means that we are going to help them draft the paperwork. We're going to type it up for them. We're going to review it with them to make sure that they kind of understand what the process looks like, what they're asking for, and help them write out the incidences of violence in a way that the judge is going to comprehend. Does that make sense? So they come in. They're going to fill out a petition for a protection order. In that petition, they are going to list their name, their address, the respondent's name, the respondent's address. You don't have to remember all of these things. There's actually a copy of a blank one, I believe, in that packet as well. So there should be a blank looking form in there.
the Superior Court of the District of Columbia Domestic Violence
Yep.
Unit?
Yep.
Okay.
So that is what the people are going to fill out if they're self-petitioning. If they're getting an advocate to help them, we're going to type it up. So you can see in the upper left-hand corner, they'll put their name, their address. If it's unsafe, so the respondent is going to get a copy of this paperwork. So anything that they write on that, they need to know that the respondent is going to be able to see. So if it's unsafe for them to list their address, maybe the respondent doesn't know where they live, they can put confidential on there. They're going to put the respondent's name, the respondent's address. They're going to list their residency, so whether they live, work, or go to school in D.C. They're going to check the box for their relationship with the respondent. And then at the bottom, you'll see that they're going to list the incidences of violence, right? So they're going to be asked for an approximate date and an approximate time, and then a narrative of the incident that happened, as well as the location where the incident happened. And they can fill as many incidences out as they want. And then if you flip to the next page, you'll see a whole bunch of checkboxes. So those are the different types of relief that are available through the protection order process. A lot of folks refer to protection orders as restraining orders, but that's actually a very separate system. The restraining order system is for folks who fall outside of the scope of the protection orders. So like neighbors who they're not roommates, but they live next door to each other, they can file for restraining orders. Strangers with no other types of relationship, they can file for restraining orders. But the protection order system is specific because it provides a lot of relief that the restraining order system doesn't provide. So if you go through that order, we'll start at the top. The most basic type of protection order that someone can get granted is called a no hats order, HATS. And that's because it's most basic order, and it means that the respondent cannot harass, assault, threaten, or stalk the petitioner. Now, all of those things are already crimes, right? But the idea is that through the protection order, there are other things that the petitioner can get granted. So they can have the respondent go to different types of counseling programs. They can ask for custody of children. There are other types of relief that they can get. So sometimes folks will want to come in and get a no hats order because they want to maintain the relationship with the respondent. Maybe they want to still live with them. They still want to try and have a relationship with them, but they want them to go to drug counseling. And they want the judge to make them go to drug counseling. So they can come in, they can file, and they can just put that no hats provision in there.
Where is this no hats?
So it should be the very first checkbox. After the front page of the protection order, there should be a next page. And the first line should be, the respondent shall not harass, assault, threaten, or stalk the petitioner and or their children.
One, ordering respondent not to abuse, threaten,
Yep.
or harass me and or my children, and or not to physically discipline my children.
Yep, exactly. So the language has changed a bit depending on kind of which form version that we have.
Gotcha.
But typically they refer to it as a no hats option.
Okay.
The next one is the stay away portion. So the judge can say that the respondent has to stay away from the petitioner, their workplace, their vehicle, the children's school or daycare, and then the petitioners can actually list other places that they frequently go that they think the respondent will come looking for them. So like sometimes we'll have folks who they list their faith community, like if they go to church, they'll list that because they know that the respondent might show up to their church. And generally this defaults to 100 feet. So it's not that far, but it's enough to keep them within a distance, right? You can also put exceptions in protection orders. So I've worked with a number of students that were enrolled in different types of graduate programs in the area. And I had one client who, she was a law student and her respondent was also a law student. So she put an exception in there that he had to stay 100 feet away from her at all places except for in their law school building. He could be within 10 feet of her in that building because they had to share. She didn't want him to get kicked out of classes. So she could put an exception in there as well. The next is no contact. So generally that's no contact by phone, no contact in writing. And then the last one is no contact through a third party. And that can be anything from social media to telling a friend to tell the petitioner, so he can't send messages through other people as well. All of those would be violations of the protection order. A few other big things, the big ones that we often talk with clients about, is that you can get granted custody of shared children through the protective order process. So a lot of times, survivors, especially for the next couple of weeks, they might need emergency custody of their children, because in DC, custody defaults to joint custody. And what we see a lot is something called parental kidnapping, where as a way to get back at their victims, abusers will take their kids and kind of hide out, because ultimately the police can't do anything because it defaults to joint custody. So part of the protection order process, they can come and get emergency custody granted through the protection order. They can also ask for child support within the protection order. So what we know is that it takes a really long time. If someone wants to file a child support claim, it can take up to 8 weeks to get that first hearing for child support. So they've created an expedited process for victims of domestic violence to be able to request and get granted child support through the protective order process while they wait for a longer child support case.
Okay.
A couple other big ones. You can get someone vacated from a shared residence. So there are two things that have to be true. One, your name has to be on the lease. So whoever the petitioner is, their name has to be on the lease unless they're married to the respondent. So if me and Billy live together, both of our names are on the lease, I can get a protection order and get him vacated from the shared residence. So the police will actually come, they will escort him out of the property, and that's often when we're sending locksmiths in to go and do emergency lock changes. That way they can't get back into the residence. Now that thing is also true. You can get someone vacated if you're married, even if your name is not on the lease. So Billy and I are married. Billy's the only name on the lease. I can still get him vacated from the residence, even if my name is not on the lease, because we're married.
But if you two are not married and his name is not on the lease, then he can't be vacated?
If my name is not on the lease.
Oh, okay.
So, like, if his name is on the lease but mine's not, we're not married, I can't get him vacated.
Gotcha.
And so that's often when we're putting folks in emergency housing.
Okay.
Let's see what else. Another big one. So the only type of domestic violence offender counseling that's available in DC at this time is through the protection order process. So the judge can remand respondents to different types of counseling programs. That includes substance abuse, alcohol abuse, domestic violence, and parenting classes. And so right now there are no offender programs, like voluntary offender programs. So CSOSA, which is the Court Supervision and Services Agency, they're the probation and parole in DC. They're the ones that actually execute all of those programs that you see, all those counseling programs.
Okay.
So if the judge remands someone to a counseling program under CSOSA, even if they haven't been convicted of a criminal case, they're still going to be assigned to a probation officer. The other big ones, I think. So they also, any shared property you can ask for in a protection order. That's where pets would go. So sometimes we have clients who have pets. They can include their pets in there so the judge can give them custody of the pets. The other big thing is that if you have a CPO against you, so the 1-year order, you have to relinquish all of your legally owned firearms, generally within 24 hours of having the protective order granted against you. So it's not true for TPOs right now. It's actually a national conversation that's happening across the country, is whether or not that gun part should be a part of the temporary protective order process. But right now it's just for civil protection orders.
So why would you get a TPO versus a CPO if the TPO offers more protection for longer?
Great question. So the TPO is really, it's something you can get the same day. So if I come in to file for my protection order and I need emergency safety services, I can get a temporary protection order that same day because my civil protective order case isn't going to be heard for about 2 weeks. So when you come in and file, you're going to fill out that same petition is going to be used for the TPO and the CPO. It's not two separate processes. It's two pieces of kind of the same bigger process. But the TPO, you're right, it's much more limited in scope and it's shorter. So typically, the TPO is meant to cover the gap in time between when you come and initially file and when you come for your CPO hearing date.
Gotcha.
But the TPO, that leads us into a good piece. The TPO has much more limited provisions. It doesn't cover all of those things. The TPO only covers the no hats piece, so no harassing, assaulting, threatening, or stalking, the stay away, the no contact, the children in common, and the vacate provision. So those things a judge can grant. So if someone comes into the intake center, they fill out their petition, they can request to see a judge that same day. Now that hearing is something called an ex parte hearing, because meaning that it's only the judge and the petitioner that are in that room. The respondent isn't there and doesn't have the opportunity to refute the claims against them. So the judge can only limit someone's civil liberties so much without them having the chance to refute the claims. So the idea is that the temporary protection order is put into place for emergency safety services for a short amount of time to keep the person safe until they can come and both parties have the chance to talk about the claims at the CPO hearing. Now, one thing about the TPO process particularly is that it's enforceable but not punishable until the respondent has been served with the paperwork. So between the time that someone comes in to file for their protection order and when they come back to court 2 weeks later for the CPO hearing, they have to serve the respondent with the paperwork. And DC, unlike a lot of other types of kind of civil litigation, DC require, I think it's all protection orders, require in-person service. Meaning that you can't send it certified mail to someone's last known address. It has to be someone in person giving it to the respondent and then signing off on a form. So there are two types of service that we generally talk about with clients. The first is what we call self-service, which is a misnomer because petitioners cannot serve respondents with the paperwork. What they're serving them with is a copy of the petition so that the respondents know the allegations against them, a copy of the temporary protection order if it's in place, something called a NAHOTA. It's a notice of hearing and to appear. So it's the sheet that tells them when the next court date is, what time it is, what courtroom it's in, when to show up, things like that. And then inside that packet of paperwork is going to be something called a return of service slip. And that is for our clients the golden ticket, the thing that they have to have with them when they come back for their CPO hearing. So self-service, what it means is that anyone over the age of 18 who is not a party to the case can serve the respondent with the paperwork. So not a party to the case means that they're not going to act as a witness. They're not someone who's getting granted any type of protections within the protection order. So it's got to be an unrelated third party who can serve the respondent. And all service really means, it doesn't mean that they have to watch them read it. It doesn't mean that the respondent has to sign off on anything. They can literally just toss the packet of paperwork at their feet, and that's good service.
Gotcha.
But what they do have to do is there's a piece of paper in there called a return of service form. And that form is the piece of documentation that the person who does the service has to sign and date and bring back with the petitioner to court for the CPO hearing. Because that's the only proof that they have that the respondent has been notified of the court date. It also, I said it's when the temporary protection order goes from being enforceable to being punishable. So the punishment for violating a protection order. So a civil protection order in and of itself is not criminal. But if it's violated, so if the respondent knowingly does something that the judge has ordered them not to do, it does become a criminal offense. And the punishment for violating a protection order is up to 180 days in jail and or a $1,000 fine. So say, for instance, I say that the respondent can't come within 100 feet of our child's school or daycare. We have a child in common, and he can't come to the school, right? So the respondent has yet to be served. They show up to the school to try and get the kid out of school. The school can say no. The school can enforce the protection order. But he can't be held accountable to the punishment unless he's been served. So
Okay.
that makes sense?
Mhm.
All right. So once he or she, once they are served, that's when, if they violate it knowingly, then for each violation, it can be 180 days in jail up to a $1,000 fine.
Gotcha.
So fast forward, so they've come, they've filed, they've met with a judge, they've gotten granted their TPO, service has taken place. We're going to fast forward to the day of the CPO hearing. So everyone is expected to show up to the courts at 8:30 a.m. And there are two courts that hear domestic violence cases. DC has created a specific domestic violence court. So it's courtrooms 113 and 114. And when they come, they're going to check in with the clerk. So stationed between the courtrooms, there's going to be a big podium. And there's going to be a clerk there checking parties in because they're going to want to see who's present and who's not present. The first cases typically that a judge is going to call are the cases where one or no parties appeared. So sometimes we're working with clients, and for whatever reason they can't make it to their court date, or it's unsafe for them to make it to their court date, or they no longer want to pursue the charges, they no longer want to pursue the protection order, so they might not show up to their court date. If the petitioner does not show up to their court date, the case is going to be dismissed. Now, there are two types of dismissals. The most common type that we're going to hear is something called dismissed without prejudice, meaning that if that same person wanted to come back and file again using the same allegations that they had in their initial protection order, they can. So nothing new has to happen. Sometimes this happens because we'll have clients who are running late, like they wake up late and they miss their court hearing. They don't get here in time, so they can just come right back upstairs and refile without anything new having happened. The other type is dismissed with prejudice. We see that very infrequently. I think it was 7 times total last year out of 5,000 cases that were filed. What that means is that the petitioner cannot use the allegations listed in this protection order to refile again. So this is only really going to happen if the judge feels like the petitioner is wasting the resources of the court. So like if they've filed using the same allegations multiple times and just never come to court, that's really the only time the judge is going to be dismissing with prejudice.
Gotcha. But if the petitioner actually shows up,
Mm-hmm.
have you ever seen that dismissed with prejudice?
I have not. Typically, the judge is going to be asking. So if the petitioner does show up, the petitioner can request for the case to be dismissed themselves. They can actually ask for it. Maybe they showed up to the court case because they didn't know they didn't have to. Typically, it's going to be if the judge feels like they're using this protective order court to get back at somebody in a way that's not actually used for safety purposes. But it happens so infrequently. And I think most of the time that it's happened, we haven't seen it happen a lot with intimate partner violence. We see it happen a lot with other types of that intrafamily offenses.
Gotcha.
Yeah, great questions. So if the petitioner shows up and they can either ask to dismiss the case, or if they were unable to serve the respondent. So they had the 2 weeks to serve the respondent, they were unable to do it, they don't want to ask for a continuance, then the judge can dismiss the case until if the person ever wants to refile again. So dismissals, nothing happens. If the petitioner doesn't show up to court, there's no one's going to come looking for her or him. It'll just be dismissed.
Gotcha.
Now, if there was a temporary protection order in place and the case is dismissed, that temporary protection order is no longer valid.
Okay.
Because it only lasts those 14 days.
Gotcha.
So let's say the petitioner comes to court and they were unable to serve the respondent, and they think they know that they can serve them sometime in the next 2 weeks. The judge can issue a continuance. So typically they'll put the court case out for another 2 weeks and give the petitioner another 2 weeks to try and serve the respondent. And often they'll extend that temporary protection order for the duration of that time as well. There are other types of continuances that can get granted. So sometimes a respondent will ask for a continuance because maybe they just got served the day before. They want time to get an attorney. They can also ask for continuances as well. But that TPO, if in place, will still be extended generally.
Okay.
So the next one, so say, say the petitioner successfully serves the respondent. And the petitioner shows up to court, they have their return of service, but the respondent does not show up to court. The judge is typically going to grant something called a default order. So they're going to make sure that those three pieces are true. They're going to make sure that there was a certain type of relationship, they're going to make sure that there's residency, and they're going to make sure that a crime occurred based on what's written in the petition and any questions that they might ask the petitioner. And then they might just go ahead and grant the protection order. So they're going to go ahead and grant that CPO. And they're also going to issue a bench warrant for the respondent's arrest.
Why just because he didn't show up to court?
Yep, so they didn't show up to court, and a bench warrant's not an active arrest warrant, so there's not going to be anyone looking for the respondent.
Gotcha.
It's going to be if the respondent comes into contact with law enforcement really for any other reason, whether it's a traffic violation or whatever. It will be in the police's system if they happen to interface with the respondent again. But all that's going to happen is that the respondent's going to be brought in. They might be held overnight, depending on what time it is, and then they're going to be brought to court and served with that default order in open court.
Gotcha.
So that it's on the record that they were served. And so the idea for that too, so if someone had a temporary protective order, the respondent was served, that TPO is going to be extended until the respondent is served with a default order.
Okay.
So the last piece is if a petitioner and respondent both show up to court. So the first thing that's going to happen is that both parties are going to meet individually with a person called the attorney negotiator. The attorney negotiator they work for the court system, and they're trying to save the resources of the court. So they're trying to come to a decision between the two parties without having to go before a judge and have a whole hearing. So they're trying to convince either the petitioner to dismiss the case or the respondent to consent to the case. So in that process, they're going to bring the petitioner in, they're going to review the terms of what they asked for, then they'll bring the respondent in and see if they're willing to comply with the terms of that protection order. Or, conversely, what could be negotiated to, if they added something or took something out, that they would be willing to then comply with the protection order. So that process will go back and forth. They're going to be negotiating, seeing if they can come to a decision. If ultimately the respondent is willing, if they say, fine, I'm willing to comply with the terms of this protection order, then a protection order will be granted, and it'll be called a consent with admissions or without admissions. So you'll see these acronyms as CWOA or CWA. The only real distinction is most of them are going to be consents without admissions, because what they're saying essentially is that, yes, I will abide by the terms of this protection order, but I did not commit any of the crimes that are alleged in this order.
Gotcha.
Now, if they consent with admissions, typically we're only seeing that if they've already been convicted of a criminal case that's associated with that. So we see it very infrequently.
Okay.
Now, if the two parties are unable to come to a decision, that's when they're going to go into law and order style, full litigated case, where both parties stand in front of the judge, they have evidence, they have witnesses, they do cross-examination, the whole thing. And at that point, it's up to the judge to either grant the protection order or deny the protection order.
Okay.
And that's everything. Any questions about any piece of that process?
No.
So the big things on the response line that we're talking with folks about are what can someone get from a protection order? So what are the actual types of relief that are available? Service is a big question that we get. Service, yep. So one thing that we can look up we have access to the civil side of the court system. So we can look up I forgot to talk about MPD service. So there's self-service, which I talked about, someone over the age of 18 has to serve the respondent. The other option is that MPD has a specific warrant squad that goes out to serve paperwork, to serve protection orders. And they go out Monday through Friday from like 6 a.m. to 2 p.m. to try and execute and serve the paperwork, but they have to have a specific address to do that. So if the petitioner knows exactly where the respondent lives or exactly where they works, they can send the police out to serve that paperwork.
So why would they choose something besides the MPD service if the MPD service is like kind of, I guess, more like concrete because it's a police officer saying they did it versus like a friend saying they did it?
Yeah, so typically they would do it, especially a lot of our clients, their respondents are housing unstable. So maybe they were living together previously and like after the incident happened, they don't know where the respondent is staying anymore. And they might not have a regular workplace that they go to. Or they might not have a specific address. Sometimes, especially if it's dating relationships, they might be able to actually like take you to where the person lives, but they don't remember the specific address or the specific apartment number is a big thing. So like the police can't go to an apartment building. They have to go specifically to the apartment unit. Right. And sometimes people just don't want the police to get in their business, honestly. Like, they think it'll escalate the violence if the police show up with a protection order, as opposed to if a third party does it.
Okay.
Different reasons.
Yeah, of course.
Yeah, but the other piece, too, is that it often takes about 5 days for the police to be able to serve a respondent. So, sometimes people feel more comfortable, like, if they just show up at their home and they have a friend who's willing to go with them, they can get the respondent served the same day.
Gotcha.
The other thing, too, so this is one thing that we talk about with service with our clients sometimes, is you can use the police with your self-service packet. So an example would be, if I get a self-service packet and I know that my respondent is at home right now, I can go to the nearest police precinct, tell the police officer at the front desk that I have a protection order that needs to be served, and that officer can escort me home and serve the respondent with that self-service packet right then and there.
Gotcha. So that would be like, maybe you don't know exactly where, like you don't have the address to MPD, or you just want it done immediately, but you're not sure of your own safety.
Yep.
So you would get a cop. Okay.
Exactly. So like if you know that he's hanging out in Kenilworth Park, but you don't know exactly where he is, or you can't describe him well enough, you can go get an officer and have them escort you to go and serve the respondent. Okay. Especially for like vacate orders. So if they're sharing a residence, we see that happen pretty frequently in those cases because they want the respondent out now.
Gotcha.
So we get a lot of questions about like, I think my friend just served the respondent, I'm so excited. And then part of what we're talking about is making sure that they're bringing the documentation with them to court, because otherwise if they don't have that return of service form, the judge has no proof that the respondent was served. We can also check to see if MPD has successfully done service in our database system. So sometimes our clients, if they request MPD service, will call us to check on the status of MPD service, and we can look that up in the database.
Gotcha.
All right, we talked about the forms of relief. So we talked about the violations. So violation of a protection order, either a temporary or a civil order, is 180 days in jail or a $1,000 fine, up to a $1,000 fine. The last piece, though, a petitioner can never be arrested for violating their own order. So a petitioner, in theory, could call a respondent and not get in any legal trouble. So they cannot get in trouble for violating the terms of their own protection order.
Okay.
We talked about service. So modifying, okay. So for both the civil and the temporary protection orders, say that someone got granted a no-hats order. That's all they wanted initially, but something happened 6 months later and they want to add extra protections in their order. They can come back and they can file a modification of their protection order. So they can come back, they fill out a form saying what new protections they want added. Then the clerks will set a new court date to hear the modifications.
Okay.
Same for removing the order. So sometimes we have clients who 6 months later, they no longer want to have the protection order in place. They want to resume their relationship. They can come in and they can file for a vacate as well, but the judge is still going to have to hear the case before they're willing to vacate the order.
Okay.
Same with extensions. That's not listed on the slide, but the orders are 1 year in length. If someone wants to extend their protection order longer than a year, they can come back generally about 2 weeks before the order is set to expire, at least 2 weeks, and they can request for it to be extended.
Okay.
Um,
So if you were to request to vacate
mhm,
your CPO against your abuser,
mhm.
and then you go back in and ask for another one, is the judge likely to grant it to you a second time?
So yeah, there would have to generally be new incidences. So you couldn't,
Right.
if you got it vacated, you couldn't use those same incidences to refile again. We try and do a lot of training, so we get a chance to train the judges generally once a year and talk about this stuff. So we'll talk with them about why someone might choose to vacate an order and still need protections later on. So I've never seen it as an issue, but if it ever has come up, we also work with a group of attorneys that do appeals work as well. So if anything ever need to be appealed, we would contact them.
Gotcha.
Most of the time, what I've often seen judges do is actually if someone comes in to file for a vacate, sometimes the judge, because ultimately they have all the authority, they'll put into place, as opposed to vacating the entire order, they'll make it a no hats order. So they'll take out all the rest of the provisions and keep that no hats order. So if something were to happen, they could come back and adjust it. All right, cool. All right, any questions about the civil process?
No.
All right. So the last thing I'm going to talk about, there's not a slide on here, and it's so rare you won't need to know about it too much, but you might hear the terms Emergency Temporary Protection Order, or ETPO. So sometimes there are folks who cannot wait until the next business day to get a protection order, especially on 3-day weekends. It happens not too frequently during weeknights, just because typically we can put some kind of an intervention into place for those few hours. But there is a process called the Emergency Temporary Protective Order process, and it's a process that SAFE runs. So the best way that I have to describe it is to give a little narrative of one that happens. So they happen about 2 to 3 times a year. Super infrequent, but it happens through the response line. So just in case you ever hear the term ETPO, you'll want to immediately call your on-call supervisor.
Okay.
So basically in ETPO, we had a situation one time where an abuser it was Friday night. The abuser got locked up for simple assault, domestic violence. They were held overnight. They were released the next day and no papered, meaning that we'll talk about in a second, there were no criminal charges that were being brought against them. So they were just released back. The respondent came back to the shared residence and just had a verbal altercation with the survivor. Right? Nothing happened. There were no threats. There was no more physical violence. The police were called and they came out, but the police couldn't rearrest him because he had already been arrested and he had been released, and there was nothing holding him back from the residence. It was his residence as well. He had been living there for more than 30 days, which is what DC's squatter laws are. Even if you're not on the lease, if you've been living there for more than 30 days, then you have rights to the home. So they called us, and typically we can put other interventions into place. So typically we can put someone in emergency housing until the next day when they can come and file for an order. Or they can stay with a friend or family. But this was her apartment, and she didn't want to leave it because he had previously destroyed all of her property when she had left the home alone after something like this. So she was afraid that he was going to destroy all of her property, but she couldn't get him kicked out. So an ETPO is an emergency order that can be issued during off-court hours. It's not ideal for a lot of reasons. So it takes about 6 to 7 hours to get granted an ETPO. Because what has to happen is that, one, there has to be some kind of police involvement. So it doesn't have to be a criminal police report, but the police have to be involved in some way. The next thing is that everyone has to go down to the 7th District headquarters. That's where the whole process takes place. So the person who's filing for the protection order would have to go down to the precinct. An advocate from SAFE would be dispatched down there as well. Then they would have to swear in the next thing is that we have to call the Office of the Attorney General, the on-call person, to see based on the incidences that have happened, do they think that this is going to qualify for an ETPO? They have to approve it. Then they have to swear the front desk officer in as the clerk of the court. And then they have to phone in the on-call judge. So it's a big process, but ultimately, for this client, it ended up great because she got granted her ETPO. So the ETPO, it only includes vacate, stay away, no contact, and no hats. It doesn't include custody of children, which is a big thing.
Gotcha.
The other thing is, as opposed to having 2 weeks between when you get granted your TPO and your court date, it's 5 business days from when you get granted that ETPO until your court date.
Okay.
So you have 5 days to get an attorney, you have 5 days to collect your evidence, so it's really short term. But for some of our clients, it is a great option if, kind of all the perfect storm of things happen.
Right.
It is a good option for some folks.
Okay.
So you hear ETPO, just call your supervisor.
Okay.
All right. Having a good time. All right. So the criminal process. Often this is where the response line particularly is coming into play right at the beginning of this process. All right. So there's a chart in your thing, what happens when someone calls 911. And I'm going to use that mostly as my framework for how we talk about what happens. I'm going to start with what happens when 911 is called. So most criminal processes start either when 911 is called or when someone walks into a police headquarters and files a police report. When the police come out, the first thing that they are going to do is they are going to separate the parties and they're going to interview both parties. What they're looking for is what is the relationship between these people and did a crime happen? And if so, who committed the crime? Those are the 3 big things that they're looking for. Because if you look to the next slide, DC has something called a mandatory arrest policy.
Right.
Meaning that if they determine that a crime's happened, Officer Parson talked all about this, right?
Yeah.
So they have to arrest somebody. So they're showing up, they're determining what the relationship is between these parties, they're determining if a crime has happened. If a crime has happened, then they are arresting one of the parties. There are lots of types of police reports. And when the officers call to refer a client to us, it's really important that we know the different types of police reports because some of them help clients get services and some of them don't. So the types of police reports that we often talk about, the first and the most basic type of police report is something called a family disturbance report. You'll see it written as FD. And a family disturbance report is just like a domestic disturbance report. It means that there was some kind of an argument that broke out. There wasn't necessarily a crime that was committed, but I have to take a report because officers have to document every call that they go on. So
Okay.
Family disturbance, there's not going to be a mandatory arrest for those cases. The next types of cases that you'll hear generally are simple assault. So you'll see that written out as SADV. It's simple assault domestic violence. That could be anything from slapped, punched, kicked, spat on, hair pulled. Those are things that would be generally classified as simple assault domestic violence. That is an arrestable offense. The next we see a lot is ADW. So that's assault with a dangerous weapon. And typically you'll have whatever the weapon is afterwards. So ADW gun, ADW knife. It could be anything. I've seen ADW skateboard. It's whatever the weapon was that was used. So simple assault domestic violence, that's a misdemeanor charge. So that's a lower level crime. ADW is a felony level charge. So it's
What did you say ADW stands for?
Assault with a dangerous weapon.
Gotcha.
So misdemeanors, yeah, and it's a felony. So there's a higher penalty or punishment for that, yeah. Sometimes we'll hear threats to do bodily harm. That's typically a misdemeanor. What other things do we hear sometimes? Destruction of property. So maybe the only crime that they can document is that they kicked the front door in. That's an arrestable crime. So these are typically what we're getting referred to for. I'm going to have you asterisk the family disturbance and the destruction of property because we're going to come back to those later.
Okay. I'm just taking notes. Are you referring to something?
Nope, no, this isn't on the PowerPoint. This was just me kind of talking.
Okay, yeah, because I was going to say, I don't see it in the packet.
There should be a list of acronyms in the packet somewhere, and all these acronyms that I'm saying are listed in there. They're just not clumped with this part of it.
Gotcha. Okay.
So we talked about probable cause with Sergeant Parsons, so they're coming determining probable cause. Interfamily offense we talked about, so again, same relationship types. Talk about types of crime. Talk about probable cause. Talk about all this. Again, the survivor doesn't have an option in terms of once charges are pressed. One thing that officers should be providing to all of our clients are the officer's name, their badge number, the police report, and they should have a domestic violence brochure with them. So the police show up. We'll go through, the first scenario I'm going to go through is if the police show up and the respondent is present. So the police show up, they determine that a crime has been committed, they arrest the respondent. So typically arraignments happen in DC every day except for Sundays and federal holidays. Meaning that if someone is arrested on a Friday night, they're going to be arraigned and possibly released Saturday. So what'll happen is the person is locked up. It depends on what time of day that they're locked up too. So when we start talking about early morning hours around 1 and 2 a.m., they might be arraigned that same day. So if they're locked up at 1 a.m., they might still be arraigned later on that same day, depending on how many people have been locked up. So they'll get locked up. They're going to either get held at the police district headquarters or here in the courthouse, there's general holding, which is why it's a 24-hour building. So they're brought in, and the next day, whether it's any day except for the Sundays or federal holidays, the first thing that's going to happen is that the U.S. Attorney's Office, they're the prosecuting agency. They're deciding whether or not they're going to pursue criminal charges. So once MPD has locked up somebody, their job is done. It's now on to the U.S. Attorney's Office. In order to determine, one of the things that they look at in order to determine if they're going to prosecute a case is the witness willing to assist in the prosecution? So they're typically going to call the complaining witness, the person who the crime was committed against, they're going to call them one time. So that next day, sometime around 10 a.m., the complaining witness or the victim of the case should be expecting a call from some random 202 number. Because that's going to be the U.S. Attorney's Office asking them if they want to assist in pursuing criminal charges. This is especially important if victims want criminal justice pursued. They need to be getting in contact with the U.S. Attorney's Office. Because especially with misdemeanor cases, if they don't have enough evidence to move forward with a case without the witness's cooperation, they're probably going to dismiss the case.
Okay, so if they get arrested on a Monday, arraigned on Monday, U.S. Attorney's Office will call them at 10 a.m. on Tuesday.
So typically if they get arrested on Monday at like 1 a.m., the U.S. Attorney's Office is going to call them around 10 a.m. on Monday morning.
Okay, Monday, gotcha.
Yep. Now, if it happens a little later, it's kind of it's a crapshoot sometimes, right around those early morning hours, whether or not they're going to be arraigned that same day or the next day. But let's say they get locked up at 3 a.m. Monday morning, then they're going to be held overnight probably until Tuesday. Then Tuesday, 10 a.m., they should be expecting a call from the U.S. Attorney's Office.
Gotcha.
So the U.S. Attorney's Office, they're going to call the complaining witness one time, right? Which can be really hard for some of our clients, especially maybe they sleep through the phone call, maybe they don't have any minutes, maybe they don't know to answer this random 202 number that's calling them. So most of the time, this is why we really want to talk with them about this right after the incident has happened. So it's one of the first things that we want to talk about is whether or not they want criminal charges pressed and whether or not they want to assist in that. If they do, if they're high lethality, so if we do the lethality assessment, we determine that they're high lethality, we can send a lethality alert via email to the U.S. Attorney's Office right then and there. So that the U.S. Attorney's Office already has it on their desk when they come in at 10 a.m. the next day that the complaining witness wants to assist in the case.
Gotcha.
If they're not high lethality, we can do a couple of things. We can give them the phone number. So on the cheat sheet, the OCAP cheat sheet that hangs in there, there is the number to the DV papering office. We can give the clients that phone number and they can call and leave a voicemail saying what their name is, what their respondent's name is, and that they want to pursue charges, just as kind of a preemptive measure. Or we can let them know to be on the lookout for that call in the morning.
Gotcha. And you said if it's high lethality and they want to press charges, then like us sending our lethality assessment over is considered enough?
Yep. So for the volunteers, you would input all the data and you would just send an email out, or you would contact the lethality assessment team, which is just a little box that you check on the VAP step. And then the LAP team would send an alert to the U.S. Attorney's Office.
Gotcha.
But yeah, that's they take that as good enough evidence most of the time. So at that point, if they decide to paper the case, so the U.S. Attorney's Office decides that yes, they're going to pursue criminal charges against this person. It's called papering the case. They're typically going to still release that person the same day for a variety of reasons. DC has not enough jail cells for the number of people that we need to get locked up. So unfortunately, they end up releasing a lot of folks. But what they're going to do is they're going to release them with something called a criminal stay-away order. And you'll see it written out as CSAO. So criminal stay-away order, a lot of our clients get that confused with a CPO. The criminal stay-away order is very specifically for the prosecution to protect their case, not necessarily to protect the safety of the client. So the criminal stay-away order it's an order that the respondent has to sign off on before they're released from jail that says that they're going to stay away from the person who they committed the crime against and the location where the crime was committed. So that doesn't necessarily mean that they're going to stay away from the shared residence if the crime wasn't committed at the residence, right? Let me plug in my computer. So at that point, that criminal stay-away order is issued, and they are released back into the community. Any questions about that so far?
Yep.
All right. I'm going to try and plug my computer in because it's dying. All right, can you hear me still?
Yeah.
Okay, cool. All right. So if the U.S. Attorney's Office decides that they are not going to paper the case, the person is generally just going to be released back into the community with no criminal stay-away order.
When you say paper the case, they mean like pursue charges.
Exactly.
Okay.
So the other thing, along with that criminal stay-away order that they will give them with, they're also going to set a court date out, generally 2 weeks-ish from when they were released, for a status hearing. So a status hearing is where the U.S. Attorney's Office has 2 weeks to see if they feel like they have enough evidence to continue to move forward with the case. And that's typically where we fall off with a criminal case, because at that point, we're working with the clients. We've already connected them to the U.S. Attorney's Office. We're then possibly helping them with a protective order as well. And most of the time, after that first status hearing, we generally have limited contact with the clients after that.
Gotcha.
So all of that is assuming that the respondent is still present when the police show up. Right?
Okay.
So now I'm going to go back in time. We're going to go back to that initial incident, and we are going to assume that the police have found that a criminal activity has happened, but the respondent has fled the scene, which is pretty common. So the first thing that's going to happen is that the police should be looking around to see if they can find the respondent. They should make a reasonable effort to search the community to see if they can find them to lock them up. If they're unable to do that, a detective is then going to be assigned to the case, typically within 24 to 48 hours. So at that point, the detective should be trying to get in contact with the client, because what the detective is going to need to do, they're going to need to take the evidence from the police report, any photographs that were collected. They're going to need to get an account from the victim, and they're going to do a photo lineup. So they're going to have the victim pick out from a series of pictures who committed the crime against them.
Even if it's, like, your husband?
Yeah, they still have to do a photo lineup to, like, as part of their evidence collection.
Gotcha.
So at that point, once the detective has compiled all of their evidence, and this is assuming that the victim wants to move forward with the case, right? The victim can say, I don't want to pursue any charges and not cooperate. But if they want to pursue the case, the detective still might do this process. They just wouldn't have the cooperation of the victim. They still might collect the evidence. They still might have enough to move forward with the case. But the victim has the option to opt into the process. So once the detective has compiled all of their evidence, they're then going to submit that to the U.S. Attorney's Office. They're going to submit all of that evidence to the U.S. Attorney's Office to try and get an arrest warrant. At that point, the U.S. Attorney's Office is going to look at the evidence and see if they think it's enough evidence to issue an arrest warrant. So sometimes the buck stops here. If they decide that there's not enough evidence, then they might not issue an arrest warrant, and the case pretty much dies right there. But they might issue an arrest warrant. So at that point, the U.S. Attorney's Office decides, okay, there's enough evidence here to move forward. They're going to sign off on the arrest warrant. They're going to get a judge to sign off on the arrest warrant, and then they're going to send it back out to MPD to execute that warrant. So unlike the bench warrant, with an arrest warrant, they are actively going to be searching for the respondent.
Gotcha.
So they're going to be checking places out, seeing if they can find him, and then once they find the respondent and they lock them up, we're back to that same point where then the U.S. Attorney's Office makes the papering decision.
Right.
But ultimately, if they've issued an arrest warrant, they're probably going to go ahead and paper the case. So they'll issue that criminal stay-away order and possibly release them. Now, sometimes people might be held more than that 24-hour period of time, like if they have an extensive criminal history or if they have other crimes. So sometimes they have other crimes unrelated to the case that they had warrants out for. Sometimes they do hold people for longer. Sometimes they'll hold them until the next status hearing, so they might hold them for a couple of weeks.
Okay.
So it's not always that people are released, but relatively, if there's not an extensive criminal history, they're probably going to be released.
Gotcha.
Any questions about what happens if the suspect is not present?
No.
No? Cool. So, let's see. The next piece I want to talk about, so I had you asterisk the family disturbance and the destruction of property criminal cases. Yeah. So.
I thought you said FD and FABD.
Oh, so FD and destruction of property. Sorry.
Gotcha. Okay.
So, were you around when we talked about any crime victims compensation stuff?
When we talked about, I'm sorry?
Crime victims compensation?
Yeah.
Okay. So, to qualify for crime victims compensation, they have to have one of three types of documentation. They have to have a police report for a crime, they have to have a temporary protection order, or they have to have a SANE receipt for a sexual assault exam. There are exceptions
Sorry, can you say that crime victim compensation,
yep.
You have to have
a SANE receipt, so a sexual assault exam, a police report for a crime, or a temporary protection order.
Doesn't have to be a CPO, it can be a TPO?
It can be both, so you can get a CPO. It depends on what you're asking for from CBC. So
Gotcha.
To get emergency housing, you have to have a TPO. But to get some of the longer term assistance stuff, like the counseling assistance, you can have the CPO.
Right. Okay.
So the only exceptions to these types of documentation. So if you get a temporary protection order, there has to be an incident of violence in D.C. within the past 2 weeks.
Yeah.
So you can get a TPO, and maybe your most recent incident happened in Maryland, but you can still get it granted here. To get CBC eligibility, there has to be an incident in the district within the past 2 weeks. For the police report piece, a police report for family disturbance is not going to be CBC eligible because it's not a crime. And for right now, destruction of property is also not a CBC eligible police report.
Gotcha.
But if they file for a temporary protection order with that destruction of property, then it is CBC eligible.
Okay.
It's just a system workaround, unfortunately, that we've had to figure out.
Yeah.
But just in case folks need CBC eligibility services, and they have a they have a destruction of property police report, they would need to get a TPO to have that be CBC eligible.
Gotcha.
All right. So the last couple of things. So MPD is required, just like all government agencies, to provide services in someone's language of origin. If they don't have an officer who speaks that language, then they have a language line that they utilize. Children, neighbors, family members cannot be used as translators. We cannot be used as translators. So if we speak another language, we cannot translate for the officers. They need to go through the proper channels.
Okay.
Immigration status. So someone can file for a protection order. They can file for a police report, and their immigration status should not be something that comes up. It is, unfortunately. I mean, there are a lot of things around fear of deportation. So folks who are immigrants often don't call the police because of that. But it should not be something that the police are asking about.
Okay.
Those are our locations. I think that's everything that I have. Let's see. What happens when something calls 911?